Hi everyone, I hope you're okay. Today's video is about what might be coming down the track for us as private landlords. So you might be aware that the Coronavirus Act has extended the notice period for Section 21 notices from 2 months to 3 months. It also extends the notice period for Section 8 notices from 2 weeks to 3 months. So a Section 21 notice is whereby you can ask the tenant to leave your property to get your property back, and you don't have to give them a reason. So this is a useful tool for problem tenants who might be paying their rent or not, as the case may be, but it is a mandatory ground to get your property back. Section 8 notices for non-payment of rent more than 8 weeks is also a mandatory ground, and this, as I say, the notice period has now been increased from 2 weeks to 3 months. Now, you might have been aware that the last year or two, the government has been talking about abolishing Section 21 notices altogether to bring England into line with Scotland, where these were abolished a little while ago. That would mean that you effectively, the tool to get your property back if you've got a problem tenant has been taken away from you. Now, Section 8 notices would still stand, so for unpaid rent there would still be a mechanism. However, I've been taking the time to read the recent government guidance being issued in light of the coronavirus crisis that's been directed at private landlords and social housing landlords. And there are some worrying developments in there which I thought I wanted to share with you, and you might not be aware of this. I certainly wasn't. So in the recent guidance, which is available on the government website, so it's there if you want to go and have a look if you like, it talks about the government working with the Master of Rolls to implement the pre-action protocol, which is currently in use in the social housing sector. And that's basically all it says. Now, I've read that several times, but when I reread it, I thought, you know what, I don't really know what this means, so I went to find out. So the Master of Rolls is actually a person. The current person is Sir Terence Egerton, and this is a very senior judicial position, so it's second only to the Lord Chief Justice. By the very factor of being Master of the Rolls, that person is a judge in the Court of Appeal and oversees one of the appeal courts. So it's a very, very senior position. The other thing that I didn't recognise was the pre-action protocol, which currently applies to social housing. So again, I went to research this, and this is what could be coming down the track and introduced for private landlords in the future. So we do need to be aware of this and understand the potential risks that this brings to us as private landlords. So what is the pre-action protocol? Well, let me just quickly run through step by step as I found it on a social housing website. As soon as the tenant enters into rent arrears, you as a landlord, and then, assuming this comes in, would need to contact the tenant. You'd have to discuss with the tenant the reason for their arrears. You'd have to ask them to share with you their financial information, so all of their income and expenditure, so that you can then work out a repayment plan with them for the rent that they have missed. And you also need to understand, and the tenant needs to share with you, any entitlement that they have to any benefits. Now, I don't know if any of you have evicted tenants for non-payment of rent. I have. I'm very fortunate that it's only been about 4 times in the last 15 years, so it is quite rare. But in every single one of those cases, at no point when the tenant has gone into arrears do they want to discuss their financial situation with anybody, let alone me, who they owe money to. So I think that first point is going to be very challenging in its own right. Now, assuming the tenant does share that information with you, what you then have to do is agree a repayment plan with the tenant, and it needs to be an affordable repayment plan based on their income and expenditure that they've shared with you. And you then give the tenants a time limit to comply. No guidance is given on how long this time limit might be, but again, under legal auspices, I guess this would have to be reasonable, whatever the definition of that would be. The next step is, in the pre-action protocol, is to provide the tenant with quarterly rent statements at periods of no less than 13 weeks apart. So does this imply that you have to give the tenant another 3 months opportunity to be able to adhere to that repayment plan? That point's not really clear. And you need to keep a running total of rent arrears and share this with the tenant on a regular basis. You are also, as a landlord, expected to apply to the DWP, Department for Work and Pensions, on the tenant's behalf to ask them to pay the housing element of any benefit directly to you from any benefits that they might be eligible for. Not only that, but you have a requirement, potentially then a requirement, to actually help the tenant apply for benefits in the first place. Again, I don't know about you, but certainly in the current coronavirus crisis, I have been helping people apply for universal credit, and those tenants have been very open and accepting of my help. But that's because this is a very unusual situation. In the normal course of things, if a tenant has got themselves into financial difficulties, again, in my experience, they just bury their head in the sand and they just want to forget about the situation. They certainly don't want to face up to it and take responsibility for their own actions. So once you've gone through all of this, only then can you issue a statutory notice. So this, I'm assuming, would be for residential properties in the private sector, a Section 8 notice for non-payment of rent. Now, even after you've issued this notice, before you go to court and issue proceedings, you've got to go through that whole process again, and you've got to give the tenant a second chance at a repayment plan once you've issued a statutory notice. You're also supposed to help the tenant access debt advice agencies as well. So Citizen Advice, Money Advice Centre, you are supposed to help them out there as well. Now, once you've got a hearing date, you will then need to inform the tenant of that hearing date. You need to encourage the tenant to attend the hearing and express the seriousness of that situation. You'll need to provide rent statements in advance of the hearings, and you will need to evidence to the court that you have done all of these things. Even at court, once the possession hearing has taken place, after the possession hearing, the tenant has another chance to agree to the repayment plan before the court will go ahead and confirm possession of your property. Now, at this point, the tenant only has to agree to a reasonable amount of the repayment plan, so not even the full amount at this point. And certainly, again, in my experience, for people claiming either housing benefit or the housing element of universal credit, at no point has the tenant been awarded the full amount of the rent. It's always a partial amount. So this, by implication, would mean that you're not going to get the full amount of rent, even if the tenant does qualify for benefits. I think it's important to be aware of this, what might be coming down the track. Only after all of this, so effectively the tenants had 3 or 4 chances to adhere to a repayment plan, and by the sounds of it they only have to tell the court that they agree, and then you have to wait a period of time for them to default before you can go to the next period. And again, as seems to be the case in all law around private rented sector, the onus is on the landlord at all times. So if at any point, if you make an error or a mistake, or you've not provided the required evidence as part of the pre-action protocol, then the court can make an order against you for costs. They can adjourn the claim until you can provide evidence, or they can dismiss the claim out of hand. The only exception being if it's not on a mandatory ground. So I just wanted to share this with you because this is quite scary stuff. You could end up with a tenant not paying rent in your property, and you can't even get them out in a timely manner under legal reasons. At the moment, we last evicted a tenant for non-payment of rent last year. We followed the due process. We did actually do some of this stuff before I even knew what it was. So we did try and help them apply for universal credit. We did try and agree a repayment plan with them, but they just ceased all communication with us and would not work with us to help them stay in the property. And that eviction process took 7 months to get them out. So that's 7 months of unpaid rent. My experience also is that the tenant needs to give their consent for universal credit to apply the rent directly to you as the landlord. So I don't think it's as simple as just phoning up DWP and asking for them to pay their tenant's rent on their behalf. So I just wanted to draw this to your attention. Obviously, now I'm aware of it, I will be keeping an eye out on this. But I do think that as an industry, we need to be careful that the government is not sneaking in new legislation through the back door as a result of the coronavirus. So if you want information on the guidance notes or anything like that, just message me and I'd be happy to send you the link.